Good afternoon, everybody. Thank you for joining me today on this beautiful Friday. Today's topic, again, we are continuing with the series, Ethics in Action. And as my introduction, we have to remember that the Code of Ethics, it details and spells out the responsibilities we have as professional real estate agents and members of the Realtor organization. What this means to us as realtors is that any realtor with whom we work voluntarily has agreed to abide by the Code of Ethics based on professionalism and protection of the public. Realtors are subject to disciplinary action and sanctions if they violate the duties imposed by the Code of Ethics. The article that we're going to be discussing today is Article 6, which states that realtors shall not accept any commission, rebate, or profit on expenditures made for their client without the client's knowledge and consent. And when recommending real estate products or services, such as homeowners insurance, warranty programs, like the one we offer with HSA, mortgage financing, like what we have with our partners at Homebridge, title insurance, such as Reliant Title, or any other service, rug services, roofing services, contractors, attorneys, any type of service that our client might decide to use. Realtor shall disclose to the client or customer to whom the recommendation is made any financial benefit or fees other than real estate related referral fees. This is when we are referring from one to one other real estate company. This does not include it in that. But the realtor or realtor's firm may receive as a direct result of such recommendation. So this applies to anything in which our company or ourselves might get any benefit from the recommendation of that service. Standard of Practice 6-1 basically is the only one that applies to this article. For the protection of all parties, the disclosures required by this article shall be in writing and provided by realtors prior to the signing of any contract. Now, in our office, we have the written form that has to be signed, which basically spells out the different programs that we have available and services available to our clients through our affiliated services. That form is to be provided to them, as well as getting a copy of it signed to provide for our records, so we have proof that the conversation has been has happened. Because there's only one standard of practice, there are a few case interpretations in which some agents have been found to be in violation, and there are some that were not found to be in violation. The first one that I am going to go over is one in which it's called profit on supplies used in property management. When a landlord or property owner hires a real estate agent or company to provide property management services for them, we still have the same obligations, not only by law, but also by the Code of Ethics. A realtor who is a property manager for the landlord bought at wholesale prices janitorial supplies used in cleaning and maintenance of an office building which he managed. The owner, in his statements, he billed, so he would provide monthly statements about the supplies that were purchased. So even though he was purchasing them at wholesale prices, he billed the owner for the supplies at retail prices. This practice came to the attention of the owner, who filed a complaint with the local board of realtors, charging the realtor with unethical conduct in violation of Article 6 of the Code of Ethics. In questioning during the hearing called by the board's Professional Standards Committee, the realtor's defense was that the prices at which he billed these supplies to the client were no higher than the prices which the owner would have been paying prior to putting the property under the realtor's management contract. It was clearly established that no disclosure of this profit or supplies used in property management had been made, and also that in proposing the management contract, the realtor had held out to the owners the inducement of attainable economies in operation. The realtor was found to be in violation of Article 6 by the hearing panel, because there was a difference between the amount he paid and the amount he charged to the owner. Disclosure is very important in situations like this. Case interpretation 6-2 is about another property manager using vending machines or installing vending machines in a property that he was managing without consulting or getting authorization from the owner of the building. The realtor managed the client's large apartment building and made an arrangement under which coin-operated vending machines were placed in the basement of the building. 6 months after the machines were installed, the client noticed them and raised a question to the propriety of the realtor's actions in installing them and deriving revenue from them without the client's knowledge and consent. The realtor's response was that he had considered the machines a service to the tenants, which in no way affected the client's interest. He told the client that he did derive a small amount of revenue from them, which had not been remitted to the client because he felt that this revenue compensated him for his time and effort in arranging for installation of the machines and maintaining contact with the firm that operated them. He suggested that if the client was unhappy, he could seek a formal ruling by submitting the matter to the Professional Standards Committee of the Board of Realtors. Accordingly, the client did just that, and at the hearing on the matter, it was established that the realtor had not consulted his client at the time he authorized installation of the machines, that revenue derived from the operation of the machines had been retained by the realtor, and that the client had been furnished no information whatsoever in the matter until he observed the machines in his own periodic inspection of the building. It was the conclusion of the hearing panel that whether or not the presence of the machines was a service to the tenants, The giving of authority for this installation was in effect a rental of the space that they occupied, and that in the absence of any disclosure to the owner, the realtor was in fact in violation of Article 6 of the Code of Ethics. So basically, the theme of this article is that we are not, as realtors, allowed to make any profit without consulting or informing or getting authorization from our client. Standard of Practice 6-3 also has to do with a property manager and their responsibilities in respect or in relation to the manager's enterprises or business on the side. So the realtor managed a large apartment building for his client. After the building had been under his management for 2 years, the realtor acquired a vacant site adjacent to the building and developed it as an automobile parking lot with monthly rates set at $50. The realtor advised the owner of this action, feeling that it would be advantageous to the building, and the owner of the building indicated that he too felt that this development was favorable to him and his building, his tenants. 6 months after opening his parking lot, he raised the monthly rate, and when this came to the attention of the owner, he filed a complaint against the realtor with the Board of Realtors, charging that the parking rate increase represented an unethical attempt on the part of the realtor to profit by the owner's investment in the apartment building. That the realtor should have raised the rents in the building, but had instead substituted the rent increase with an increased rate in his parking lot. A hearing was called on the complaint before the board's Professional Standards Committee, and at the hearing, the realtor presented data tabulating monthly parking rates in the general area of his enterprise that showed the average prevailing rate for similar facilities or parking facilities in the area. He also presented information which showed that the rent charged for the apartments in the owner's building was relatively high in comparison with similar apartments in the area. After careful review of this data, the hearing panel concluded that Realtors A's parking lot enterprise had involved no expenditure of the owner's funds, and that his actions in establishing his business had met with the owner's approval at the outset. That the realtor's exhibits demonstrated that there was no merit to the owner's contention that a justified rent increase had been shunted into an increase in parking rates. That the owner's interest had in no sense been betrayed, and that the proximity of the parking area continued to be an asset to the owner's building, and that the realtor's actions were not in violation of Article 6. So in this situation, because the realtor was upfront with the owner of the property, and his actions did not affect the owner's building or his interest in the building, he was not to be in violation. Again, disclosure up front is very important in this particular case. The following case is Case Interpretation 6-4, in which this has to do with acceptance of rebates from contractors without informing the client. The realtor who managed a 30-year-old apartment building for the client proposed a complete modernization plan for the building, obtained the client's approval, and carried out the work. Shortly after completion of the work, the client filed a complaint with the Board of Realtors, charging the realtor with unethical conduct for receiving rebates or kickbacks from the contractors who did the work. At the hearing, the client presented written statements from the contractors to substantiate his charges. The realtor defended himself by stating that he had carried out all the work involving the preparation of specifications, solicitation of bids, negotiations with the contractors, scheduling work, supervising the improvement program, that he had presented all the bids to the owner, who had authorized acceptance of the most favorable bids, and that he and the client had agreed on an appropriate fee for his service. The realtor had also presented comparative data to show that the client had received good value for his money. After all of the contracts were signed and the work was underway, the realtor found that his fee was inadequate for the time, the work that was required, and he needed additional compensation, but didn't want to add this to the client's costs. That when he explained his predicament to the contractors and asked for moderate rebates, they agreed. Questioning by panel members revealed that the contractors felt that since they were being asked for rebates by the man who would supervise their work, they felt that they had no choice but to agree. The hearing panel concluded that the realtor was in violation of Article 6 of the Code of Ethics, and that if he had miscalculated his fee with the client, his only legitimate recourse would have been to renegotiate his fee with the client. So he was found to be in violation of the code for going around the client and not keeping him in the loop about what he was doing. The next case interpretation has to do with advertising real estate related products and services. And it is very, very important that we know the difference between a recommendation, an endorsement, and a click-through, such as when we use any type of click-through in our website to get any type of compensation. So in this particular case study, the realtor, principal broker in the firm, XYZ, developed a robust interactive website that he used both to publicize his firm and to serve the firm's clients and customers electronically. The realtor maintained positive business relationships with providers of real estate-related products and services, including financial institutions, title insurance companies, home inspectors, mortgage brokers, insurance agencies, appraisers, exterminators, decorators, landscapers, moving companies, and many others. Given the volume of business that the realtor's firm handled, several of these companies purchased banner advertisements on their website, and some, including the Third National Bank, included links in their banner ads to their own websites. The buyer, who had earlier entered into an exclusive buyer representation agreement with the real estate company, received frequent emails reports from the realtor about new properties coming into the market. Hoping to purchase a home in the near future, he explored the realtor's website to learn more about the home buying process and familiarize himself with the real estate related products and services advertised there. Understanding that pre-qualifying for a mortgage would ensure he presented the strongest offer, the buyer went to the realtor's website and clicked on the Third National Bank's link. Once at the bank's website, he found a mortgage to his liking, completed the application process, and learned in a matter of days that he was qualified for a mortgage loan. In the meantime, the buyer's property search proved fruitful. The realtor and the buyer visited a new listing on Hickory Street several times. The buyer decided that it met his needs and made an offer which was accepted by the seller. A few weeks after the closing, the buyer hosted a housewarming attended by his friend, a website designer who had coincidentally been instrumental in developing the realtor's website. The buyer told his friend how helpful the information from the realtor's website had been. You know, don't you, that each time a visitor to the realtor's website clicks on some of those links, the realtor is paid a fee? Asked his friend. I didn't know that, the buyer said. I thought the links were to products and services the realtor was recommending. The buyer filed an ethics complaint against the realtor, alleging a violation of Article 6 for having recommended real estate products and services without disclosing the financial benefit or fee that the realtor would receive for making the recommendation. At the hearing, the realtor defended himself and his website, indicating that the advertisements for real estate related products and services on his website were simply that, advertisements, and not recommendations or endorsements. He acknowledged that he collected a fee each time a visitor to his website clicked on certain links, regardless of whether the visitor chose to do business with the click-to entity or not. In some instances, I do recommend products and services to clients and to customers. In some instances, I receive a financial benefit. In others, I do not. But in any instance where I recommend a real estate related product or service, I go out of my way to make it absolutely clear I am making a recommendation and I spell out the basis of my recommendation. I also disclose, as required by the code, the financial benefit or fee that I might receive. Those banner advertisements on my website are simply that, advertisements. The hearing panel agreed with the realtor's rationale, concluding that the mere presence of real estate related advertisements on his website did not constitute a recommendation or endorsement of those products or services, and that the click-through fee that the realtor earned when visitors to his website linked to certain advertisers' websites was not a type of financial benefit or fee that must be disclosed under Article 6. So in this particular situation, the realtor was able to show the difference between recommendations, endorsements, and this particular situation, which was simply a bank getting a mortgage by a click-through banner ad. Okay, so we have to know the difference. We have to make sure that we are complying with that and that our clients understand the difference. The next case interpretation is similar but different to the previous one. And because we do have an affiliated business relationship with lender, with Homebridge, with HSI Home Warranty, and with the Reliant Title, we have obligations not only under our Code of Ethics, but also under the New Jersey licensing requirements or our state licensing requirements, but also by our federal RESPA requirements. In this particular case, the realtor, a broker and sole proprietor, had invested considerable resources into developing her website. Seeking to recoup some of her costs, she approached virtually every provider of real estate related products and services in her area, including financial institutions, title insurance companies, home inspectors, mortgage brokers, insurance agencies, appraisers, exterminators, decorators, landscapers, furniture and appliance dealers, rug and carpet dealers, moving companies, and others about purchasing banner advertisement space on her website. As a condition of having a link to their own sites appear on her homepage, the realtor required that a fee be paid to her each time a consumer clicked through from her site to an advertiser's. So this is very similar to the case previous to this. However, in this situation, the outcome is totally different, and I'm going to explain why. The ads for providers of real estate related products and services who agreed to the realtor's terms appeared on her homepage under the heading Preferred Providers. That's the problem. Preferred Providers. Immediately under that heading read, "These vendors provide quality goods and services. Please patronize them." This is an endorsement. So this is not just an ad. This is an endorsement and a recommendation for these services and providers. And that is the basic problem for this outcome to be different from the previous one that we discussed. But the buyer frequented the realtor's website seeking information about available properties using the website. He became aware of a property on Elm Street that he made an offer on through the realtor, which was accepted by the seller. The sale closed shortly afterwards. The buyer was an avid remodeler and using the realtor's website linked to the Real Rug Company website, among others. Interested by what he found there, he subsequently visited their showroom in person and purchased wall-to-wall carpeting and several expensive area rugs. Given the size of the buyer's order, one of the owners of Real Rug came to oversee the delivery and installation. In the course of conversation with the buyer, he commented favorably on the amount of referral business received from the realtor's website. "And to think that I only pay a small fee for each customer who's referred to me by the realtor," he added. The buyer was somewhat surprised that the realtor would receive money for referring clients and customers to providers of real estate related products and services and contacted the local association of realtors. The association provided him with a copy of the Code of Ethics. Reading it carefully, the buyer concluded that the realtor's actions might have violated Article 6, and he filed an ethics complaint against the realtor. At the hearing, the realtor defended herself and her website, stating that the advertisements for real estate related products and services on her website were simply that, only advertisements and not recommendations or endorsements of the products and the services found there. She acknowledged that she collected a fee each time a visitor to her website clicked on the links found under preferred providers, but claimed that simply referring to those advertisers as preferred did not constitute a recommendation or endorsement of the products or services offered. The hearing panel, in this case, disagreed with the realtor's reasoning, pointing out that a reasonable consumer would certainly conclude that referring to a provider of real estate related products or services as being preferred by a realtor constituted a recommendation or endorsement. Further, since the realtor received a fee each time a consumer clicked through to one of the realtor's preferred providers, the realtor received a referral fee, and disclosure of that fee was required under Article 6, and the realtor was found to be in violation of Article 6. So it is very important that we know the difference between a recommendation, an endorsement, a click-through ad, and also make sure that when there is a recommendation where our company will receive any type of compensation, such as when we refer Homebridge, HSA, or Reliant, that we have the RESPA form disclosure signed by that client and saved in our file. It's just good practice to have everything that we need in order to defend our case in case someone who, these last two cases, both clients were very happy with the service and with the ease of finding what they were looking for. But even with their happiness about the service, they still felt that the disclosure that was lacking was not representing their interest, and got the realtor into in front of a hearing panel. And that is one thing we definitely do not need to be in front of. So as you can see in these case studies, it's not enough to know. It's more important to practice what you know. Whenever in doubt, ask, investigate before doing something that could get you into trouble. I thank you for your time today. I hope you have a fabulous Friday and enjoy your weekend. Until next time, where we will be covering Article 7 as well as Article 8 of the Code of Ethics. See you next week.